Dear Moody's, esteemed guests and colleagues, my name is Anita Limova. Together with my dear colleague Lia Guidron, it is our great pleasure to welcome you all to the 5th Bodenheimer Pre-Moot opening ceremony.
Hi, everyone. We're thrilled to have you join us today as we're kicking off this really exciting event, and we're bringing together passionate Moody's from all around the world and in preparation for the challenges ahead. This year, we're super honored to have Heidi Merikalla-Teir, chair of the FI board, as our guest speaker. Heidi's remarkable career and deep expertise in the field make her an inspiring figure for all of us, and we're super grateful for the opportunity to learn from her insights.
And before we move into our Q&A session, we first have the pleasure of hearing from one of our Bodenheimer partners, Dr. Christoph Siefert, who made the effort to pre-record a message to all of you. We truly appreciate everyone's time and commitment to support this event, and we're excited to share his and Bodenheimer's message with you all. Following that, Heidi will share her experiences and perspectives on both her professional journey and the work of the FI. And this will lead to the Q&A session where you, our Moody's, will have the chance to build on the discussion with your own questions by posing them in the Zoom chat. So we encourage you to take the advantage of this unique opportunity to engage in a meaningful exchange with such a distinguished expert. So thank you all for being here, and we look forward to a fantastic session ahead. And with that, let us officially begin with our first virtual gathering. I will play the video now. Just give me, there it is. Please let me know if there are any audio.
Hello, I'm Christoph
issues.
Siefert, a partner with Boden.
There are audio issues, if I hear correctly. You don't hear anything.
We hear.
We can hear it. It's all good.
Okay.
It's all good.
Then I will just.
I would like to welcome.
Very quickly.
Hello, I'm Christoph Siefert, a partner with Bodenheimer. I would like to welcome you to our now 5th pre-moot for the Vis Moot Court. We are very delighted that we received almost 120 applications. It was a tough job to get 30 teams chosen by that, 13 of which are from Germany and 17 from all over the world. This is already the 5th Bodenheimer pre-moot. Last year, we, for the first time, had a personal meeting with all of you in Vienna at the renowned Café Landmann. And we will do it again this year. We are really looking forward to seeing you in Vienna in person on April 12th, on the Saturday, just after the opening ceremony. This is a great opportunity to meet the arbitrators, to meet the people you competed with. There will be some food, there will be some drinks, there will be enough time to, as we say, meet and mingle. We are looking forward hosting the pre-moot with 30 hearings over the next 2 weeks. Today at the opening ceremony, we have the honor of welcome a renowned member of the Finnish Institute of Arbitration, FAI, who will be introduced later. We all at Bodenheimer wish you a very successful 2 weeks. This is a real life experience, and we will try our best to show you how arbitration really works.
Yes, that was, how do I? Okay, so with that, I give the floor to Sebastian Feiler, who has a nice conversation with Heidi.
Yes, thank you very much, Anita, for the introduction and the greetings. And from my end and from all of the other partners here at Bodenheimer as well, a warm welcome to all of you, and welcome to this kickoff to the 5th Bodenheimer pre-moot for the Wilhelmsee Vis commercial arbitration moot. It is, as always, a pleasure to have all of you here, and we are all here at the firm looking forward to the pre-moot sessions together with you, and of course also to the in-person gathering at Café Landmann in Vienna to meet everyone who is able to come. Very much looking forward to that. This year's moot problem contains of the FAI rules. So you've gotten to know the FAI rules and the FAI intimately by now when working on your briefs and studying the rules and studying the moot problem. And this is why it's a distinct honor and pleasure for us to greet someone here today who has a very close link to FAI, I dare to say, who is representing and is breathing the FAI to a most certain extent. It's our esteemed guest Heidi Merikalla-Teir, who is not only an esteemed colleague with decades of experience in business law and conflict resolution, and especially, of course, in international arbitration, and who has not only been a CEO and partner at a renowned law firm in Finland, but who has also been a director at the Finland Chamber of Commerce, and in this capacity also Secretary General of the Arbitration Institute of the Finland Chamber of Commerce, the FAI, between 2015 and 2019. So here's someone with really intimate knowledge of the rules at the very center of this year's moot problem. Heidi is still a chair of the board of the FAI since 2022, and since 2024, she has embarked on a new venture by founding Merikalla Conflict Resolution, and she's now providing her services as an arbitrator and mediator and conflict resolution specialist from there. A very warm welcome to you. It's our pleasure to have you. And let me begin, Heidi, by asking you, can you tell us a bit about your background and how you became involved in international arbitration as a part of the many possibilities that one can engage with when entering legal studies and becoming a lawyer?
Thank you, Sebastian, and thank you for all the whole team of the Bodenheimer Moot. It's a real pleasure to be here. Thank you for the kind invitation, and thank you for all you participating on this webinar today. It's really a pleasure to be here. So as Sebastian said, I've been working with the FAI for a long time, first as the Secretary General. Then I was away for a few years and then came back as the chair of the board in 2022. I have two daughters, but I tend to always say that FAI is like my third child. So it has been in my life for so many years, and I will be chairing the FAI for one more year. So this Vis Moot year until the end of this year. And let's see how I survive after that, because it has been part of my life for so many years. But as to your question, how everything started, so I was thinking today in the morning about how everything actually started and made some notes as well. So let's see how much I recall what I was planning to say, but I graduated already a very long time ago. During the years that I studied in Helsinki University, so we didn't have any courses on arbitration. Actually, we only, when we had the exam for civil procedure, so there is a tiny little booklet on arbitration, and the book or booklet was the only book that we had on arbitration in Finland at that time. So I really didn't know much about arbitration. I did my exchange, Erasmus exchange, actually in Germany, in the University of Regensburg. But also there, I didn't read anything about arbitration. So when I graduated in 2002, so by then, I actually didn't know that much about arbitration. During my studies, I did work quite a lot for different industries. I worked for the Ministry of Justice. I worked for Nokia, which was booming during those years. And then for the law firm Rocher, which many of you may know, which is the biggest law firm in Finland. But also during those work periods, I had nothing to do with dispute resolution or arbitration for that matter. So in that sense, it was actually quite late that I became not only interested about arbitration, but also somehow involved in arbitration. But I must say that I always say to students and young lawyers that it's always important to work on many things. And during the studies, I highly recommend working, if not in law firms or in companies. So whatever you find, be it in McDonald's or cleaning places or selling shoes in sports stores, I think everything is very worth doing it. And you learn things that you will need in your later career. And when I was working as a managing partner for a law firm and was doing a lot of recruitment, so I think one of the things that I always looked at people's CVs is not only that they have done their studies. You didn't need to be the best person in your studies, but I think more importantly, I looked at the background and whether the person has been working somewhere. So that's just something that I wanted to say. But when I graduated, I started working for a Finnish law firm, BODENHEIMER, which is one of the big law firms in Finland. But also then I didn't do dispute resolution or arbitration. I started as a competition law lawyer and in their M&A practice group. I had done my thesis on competition law and economics and worked with those cases for the first part of my career, maybe first 2-3 years. And it was actually only after I did my court training. We have in Finland a 1-year court training, which means that basically those persons who want to become judges, they need to do it. But also I think most of the lawyers who work with dispute resolution, they've done the court training. And it was after that year, my court training year, that I then moved to the dispute resolution practice of a law firm. But I think it was very good and important that I didn't start in a dispute resolution practice group, because I always also tend to say to younger lawyers and students that I think it's very, very important to learn about law in more broader sense and learn about different substance areas, try different things. And maybe then if you, after that, still think that arbitration and dispute resolution is the thing you want to do, please do it, but still be curious, want to learn new things. You never know what you do in life. For instance, if I think about me, I'm in my mid-40s and still I don't know what I will be doing when I'm older. So I think there are so many interesting things in life and in business and many things you can do. So I always recommend considering at least doing some side steps and trying to do also other things than law. But that's has been kind of a part of the things that I've done in my career. So trying different things and also doing other things than law. I studied economics and did my MBA during the year that I did the court training. And I think that has been one of the best decisions in my life, because I think, for me at least, as I have not been 100% sure that I only want to do law my whole career. So for me, it has helped a lot. And now that I established my own firm where I serve as an arbitrator and mediator, I also want to widen the scope of my area also to some business related things, such as serving as a board member in different business companies. So it has definitely helped me a lot. So that is at least one alternative one can think when considering after becoming ready with the studies and working for a while, and then you maybe think whether to continue studying or just working. So instead of always doing the LLM that many do, which is a very good thing, so I think it's worth considering whether there is also other possibilities to study. But that's not a short summary, but still maybe a summary of how I became involved in dispute resolution and arbitration, and at least in Finland, and I think that applies to many other countries as well. So if you work in a law firm and with dispute resolution, so you normally do many things, not only arbitration, but also other cases in litigation, maybe even criminal related cases. I think it's very valuable. So I think doing disputes from many viewpoints in different courts, I think that makes you always a better lawyer.
But thank you, Heidi. Very, very interesting and very refreshing. And I can only say I can fully mirror that. I myself had also the experience of more or less moving step by step into arbitration, but not starting fully focused on arbitration when I started my legal career. But it just became more and more interesting, and it topped up on several areas of the radar. So you somehow move into that field. Yeah. Speaking about disputes and arbitration, and you mentioning that you turn towards a dispute resolution at some point of your career. What about the arbitration landscape in Finland? Would you consider that to be an arbitration-friendly jurisdiction? Is arbitration the favorite way of resolving disputes? Is mediation very, very popular in Finland, or is it more court proceedings and arbitration is not so prominent there?
Yeah, I would say definitely that Finland is an arbitration-friendly country. So if we think about business disputes, so most of the business disputes would be decided in arbitration. That doesn't mean that the courts wouldn't be good in deciding on the disputes. On the contrary, we have excellent judges as well, and they do understand the differences between court and arbitration proceedings. And on the other hand, also we of course cooperate in terms of setting aside proceedings and so on and so forth. But I think the problem in Finland, as in many other countries as well, is that the courts are crowded with cases. There are so many cases that the length of a dispute proceeding is in practice too long for business disputes, and that's why most of the business disputes are resolved in arbitration. And of course, if we compare the length of, for instance, FAI proceeding, which is approximately 9 months, and then compare it to the court proceedings, which at the district court, which is the first phase of the proceedings, would take, I don't know, between maybe 2 to 3 years. Then you can appeal to the appellate court, and then it takes again 2-3 years. So if you think about business and how fast everything moves forward nowadays, so it's definitely a too long period. So arbitration definitely is the most popular venue. And of course, the other reason for that being not only the promptness of the proceedings, but also, of course, that the arbitration proceedings are confidential. And then also that you are involved in appointment of the tribunal, which you, of course, cannot do at the court. So definitely arbitration is very, very popular. You asked about mediation. So as long as I've studied and worked, so mediation has been so to say a hot topic also in Finland. Finnish Bar Association has done excellent work in promoting mediation and training attorneys. I've done the trainings myself and have served as a trainer in these courses, as mediation has always been very close to my heart. And I did the CEDR accreditation as well. But still, although I would want to say that I have several mediations ongoing all the time as a mediator, that's not true, because still, if we think about business disputes, so the use of mediation is still relatively limited. The court annexed mediation in turn is and has increased. And I would say that the courts in Finland have done a great job in this respect. So if you have a dispute that goes to a general court, so quite often you would get a call from a judge saying that before you come to my services, we would recommend using mediation. And that is something that is used. But of course, when business disputes don't go to courts that much, so then the question is whether you use mediation in any other way. And I would say that it's increasingly used, but not as much as I and many others would hope for. So there is still very much room for improvement. But I would say that it requires that the lawyers, attorneys have more knowledge about mediation, that their clients have positive experiences of mediation. And that's why I think it requires that we continue talking about mediation, meeting with in-house counsel, because they are at the end the ones making the decision on where to take their disputes. So I see positive signs, but I hope more positive wind for mediation in Finland as well. So.
Very interesting. Yeah. Also interesting to hear that Finnish courts also provide mediation as a possibility for conflict resolution. That's also something we have in Germany, and that's also increasingly used in German court proceedings as well. Let's turn to the moot, the preparation of which is the purpose of this pre-moot, of course. What's your opinion if you would recommend or have to recommend the moot to students? What's the key benefit? What's the selling point in your opinion for a Vis Moot or for any moot at that point?
First of all, I must admit, as I already mentioned, I've never participated on Vis Moot myself, and as I said, it was not a hot topic like nowadays during my studies. So I think I became aware of Vis Moot only after I had graduated and started working for a law firm, and then eventually was involved in these workshops that we arrange for students. And of course, at the FAI, when I entered the FAI in 2015, so we already then knew that one day we want to have our rules for the Vis Moot. And since then, of course, we've done a lot of work for promoting FAI rules. And finally, we are here after 10 years. So the FAI rules are part of the competition, and we are very, very happy. But of course, even although I haven't been involved in Vis Moot myself, but I've seen a lot of people who have been, and I've been involved in the workshops. And I must say I'm very impressed. So I think I've been in Vienna, I've been in pre-moots, I've seen the quality of the students. So I think when I was your age, I'm not talking about for the students, so I could not have done it. So I think you are all excellent. And you are so good in not only in writing but also orally. So I'm happy that I don't need to participate in the competition myself now. So I wouldn't be as good as you are. But I think there are many benefits. So I think one of the first ones, of course, is that you learn about arbitration, which you don't necessarily learn during your studies, as is the situation in Finland. But then not only about arbitration, but I think those people who have attended Vis Moot or other similar things, so I think you learn important things about teamwork. And regardless of what you will do in the future, you will need those skills. So I think that's very important. Maybe a third point, what I thought about is that during your Vis Moot, I think students, you learn about how to present your arguments, not only orally, but also in writing. And that is, of course, something you need, even if you wouldn't be a dispute resolution, but just an ordinary lawyer, or if you do something else, you always need the skills of saying things in a clear manner, concentrating on the essential things. So I think those are the things you at least learn during the Vis Moot. So
interesting. Is that also the last thing you mentioned? Is that also the central skill of oral advocacy from your experience? Also, you sit as arbitrator and mediator very often. Is that what's most important about oral advocacy, or is there even something else that one has to keep in mind with oral advocacy?
Yeah, I think that same applies to oral advocacy in general. So I think thinking about how to present your case. So I think you need to have, first of all, of course, clear thinking. You need to know the case in order to clearly then advocate the case. And I used to say always to younger students at our law firm that, and also younger lawyers, that when you write your submissions or present your case orally, I think it's always important to think that the persons that are deciding on the case, that is arbitrators in the Vis Moot as well, so they are normal human beings. So I think you need to think how you, as a human being, would want a case to be presented to you. Most likely you would like it to be clear, very straightforward, so that you have kind of the decision tree already on your mind. So how would the arbitrator think about deciding on the case? And I always tend to say that use that kind of language in your submissions and oral argumentation that is not too complicated. This is not a competition about the finest language you find or the English words that are better than the other ones, the language that the others are using. I think the bad thing is if you as an arbitrator, when reading submissions, you need to look at the dictionary to understand a word that the parties are using. And sometimes this is actually something when I was a specialist partner at the law firm, and also when I was the managing partner reading some submissions, I was saying to younger lawyers that I would want your language to be much, not much simpler, but still not too complex, because you never know about the arbitrators and their language skills, how they prefer to read documents. So it's a tiny thing, but it can be annoying if you really don't understand what the others are saying if they use more complicated language. So just a tiny tips that I can give.
What do you think, out of curiosity, what's more difficult, written advocacy or oral advocacy? So if you look at the case from a counsel perspective, is it more difficult to write the submissions and draft them skillfully and clearly worded, or is it more difficult to provide a good performance, so to speak, in oral advocacy?
I think it depends on the person, because I think there are people who are very good orally, or people that are very good in writing, but they maybe are not that good orally. So I think it varies a lot. But I think writing a submission in a coherent and brief manner, so not to have a submission that is too long, because that's not good either. So I think that requires a lot of skills and time. And sometimes I think about the clients, and if they receive a submission that is 10 pages long compared to a submission of 20 pages long, so what they value? They might think that, okay, 20 pages, so this is a better one, but it doesn't necessarily mean that. It's difficult to write in a comprehensive but still in a very, very clear manner. And I think it's better as an arbitrator when I see a lot of submissions. So I prefer having a 25 pages submission that is full of important things than 50 pages of repeating the same things and wording them just in a different manner. So it's not easy, but I think some dispute resolution lawyers have the important skill of having the skill of summarizing and having good texts. And then to the oral advocacy, as I said, it depends on a person. Some people are excellent in oral advocacy, and that may compensate for even submissions that are not that good. So.
And that's maybe also an aspect where teamwork comes in, right? If you have, ideally,
absolutely.
if you have someone who is very well in drafting submissions, and if you have him complemented by someone who is a good oral advocacist, then well, what can go wrong?
Yeah, I think that's the perfect match then. So
yeah. Very good. Let's move to another subject and more to the Vis Moot problem. At the center of the Vis Moot problem this year, every year it's another set of rules. This year it's the FAI rules, and of course every arbitration practitioner looking at the problem, and also every team member of moot teams, it will probably ask themselves, now we are dealing with the FAI rules, we have to look into those, but in comparison, what's different about the rules when you compare them to, for example, the ICC rules or other rules? Is there anything that stands out, or that is highlighted, or that's probably resembling a specific notion of arbitration in Finland? Anything that you can point us to with respect to the rules there?
The FAI rules were completely modernized in 2013, so that was a kind of a starting point for a new modernized FAI. And when the rules were modernized, so inspiration was taken from the ICC rules that were in force at that time. Of course, after that, both the ICC rules and the FAI rules have been amended and for many times, and some modernizations have had done. But still, I would say that the FAI rules, they are very similar to the ICC rules, maybe the SCC rules. So have the similar kind of elements as international modern arbitration rules would have. So I don't see any such differences that would be worth mentioning. I think we have all the elements that the other rules have as well. And then, of course, what we consider as an advantage for the FAI arbitration is the fact that it's pretty fast. And the reason for it being that we have in the rules, as many other rules have as well, we have a time limit for rendering the award, which is 9 months from the date when the case file was transferred to the arbitrator or the tribunal. However, maybe the difference is that we all know that also the ICC rules have a time limit for rendering the award. But as far as I understand, the time limit is extended quite a lot. And the duration of the proceedings is maybe closer to 2 years than 1 year. But the statistics show that under the FAI rules, the medium duration is 9 months. So we keep it there. Of course, if there's a reason to extend the time period, if the parties agree and parties and the tribunal agree, so the FAI will extend it. But still, I think the arbitrators and the parties will, in most cases, that it is decided within the time period. And also, if we think about Finnish arbitration and the Finnish Arbitration Act, so if the arbitrators do not render the award within the time limit, so they don't anymore have jurisdiction. So that is something we need to sometimes clarify to international arbitrators, that if there is a time limit in the rules, that means that it is really a time limit.
Yeah.
And then it needs to be extended if needed. But you cannot just say that, okay, I didn't have the time and I will deliver it in 2 weeks. So that's not how it functions in Finland. So.
Very interesting. And also, this is, in fact, I think this is something that has to be highlighted in comparison to other jurisdictions and other rule sets and other arbitration laws, where this is probably regarded a little bit more loosely or relaxed. Yeah, interesting.
I was involved in we had a panel discussion here in Helsinki, it was last Friday, in connection with the Helsinki Pre-Moot, and Ulrike Kantenberg, some you may know, a very reputable arbitrator who has also been serving as an arbitrator in FAI rules. So she was saying that, and when she gets the FAI rules, so that's the worst thing in the rules, that you really have the time limit, and we are following the time limit. So, but that's how we function, and I think that's really a benefit of the FAI rules. And although many of the FAI cases are decided by sole arbitrator, which is actually the presumption if the parties haven't agreed on the number of arbitrators, so you will have a sole arbitrator unless there are circumstances that then require a 3-member panel, but also the 3-member panels, I think they comply with the 9 months time limit. So I think that's something that it's also a mindset. And I think the clients appreciate having fast proceedings. Of course, at the same time, fastness is one thing, but you need to have quality proceedings and quality award. And that is, of course, something we also look into and always read the awards. And even though we don't have the scrutiny like the ICC, so we read them always afterwards. And we want to make sure that the quality of the awards is good. And it's not that it only needs to be fast, it needs to be fast and good. So and cheap.
Fast and good.
Clients want to have it cheap.
Fast, good, and cheap. That's I just was going to say fast, good, and cheap. That's what the clients like. The combination of these three, which is
exactly.
very challenging indeed. Yeah. You mentioned the reform of the rules. Is there anything on the horizon for the FAI rules in the upcoming year or years? Are you looking at further steps of reform? Anything else you want to add or change in the rules, or any development you want to catch?
There is nothing very big that needs to be modernized now. Of course, there are things we are doing. We are trying to establish the FAI platform. have everything digitalized, and we have already done some pre-work for that. That is something we want to hopefully have ready by the end of this year or in the beginning of next year. So that in terms of making everything digital, that might require some changes to the rules as well, but nothing big. Then many things we think about, nothing planned yet. But I think these tiny things, but otherwise I don't think there is nothing major coming up, because I think the rules function very well. And also from the client's perspective and from the user's perspective, so that is lawyers as well. So I think it's not good if rules are changed every year just to say that we have the new rules. So I think that's not a good reason. You change the rules if there is a need. But I think if there is no need for changes, that's a good thing. So,
yeah, I agree. Interesting. Going back to the moot problem, but staying at the FAI rules a bit. One of the problems of the case, of course, this year revolves around the fact that there is a somewhat combination of an arbitration and mediation clause in the contract at hand of the moot problem. Is this something that you see as a practitioner as well? Mediation arbitration clauses, are they commonly used in Finland? Do you see them in FAI arbitrations? And if so, and in general, what do you think? Is this a beneficial way of having clauses in contracts, or should you leave the mediation clause out and then look for a customized procedure of mediation when it makes sense in a case?
Yeah, that's a good question. I think that, of course, we at the FAI see only those cases that becomes disputes and are filed to the FAI. And I would say that in most of the cases, we don't see a combination clause or multi-tier dispute resolution clause. There might be a clause saying that you need to negotiate first before going to arbitration. So that is pretty common. But maybe only a couple of times I'm recently seen a clause including mediation. However, that doesn't mean that the parties wouldn't be able to use mediation or that they wouldn't use it. I think more and more lawyers, attorneys, counsel, they know that mediation is a good tool. And although the arbitration clause wouldn't include a reference to mediation, so they still use mediation before arbitration or during an ongoing arbitration proceeding. So in a way, ad hoc arbitration, and if you, even though you don't have any mentioning, so it's still available and is used. But as I said previously, I think there is room for improvement in this respect. But on a general level, I think multi-tier dispute resolution clauses, they are good, but I think there are many pitfalls as well. And that's why I always recommend using the model clauses, because of course they are thought through, so by the institution that they work. And we have to remember that arbitration and dispute resolution clauses in general, they are normally not drafted by dispute resolution lawyers. They are drafted by maybe M&A lawyers in a law firm or client by themselves, who are not necessarily even lawyers. So I think if we think about this, so then I think it's the safest way is to use the model clauses. I always say in different trainings where I talk about arbitration that we lawyers tend to like the fact that we can do complicated agreements and so that we see that we have been involved in drafting the agreements. But I always say to lawyers that don't use your effort in the dispute resolution or arbitration clause. Use it to the other sections of the contract and let the institutions, if you have an institution arbitration, tell you how the arbitration clause should be formulated. So if you need to copy paste something, please copy paste the model clause. So that would be my recommendation. So
it's interesting that you mentioned various situations in which these clauses are inserted, maybe even at the last moment. I can remember one or two instances in one of the law firms I worked with previously, where there were some last minute calls asking, well, is that fine? Can I just copy this wording into this clause, into this contract? You don't need to know the details, but just tell me that I'm okay with just copying it in there. Yeah.
But at least you got the call, because quite often you don't even, as a dispute resolution lawyer in a law firm, you don't necessarily get the call.
That's right. That's
so you
right.
have had the call, so that's one step forward at least.
That's right. I'm wondering, is there a need for more customized but still model clauses? Do you think it would make sense for institutions or for other platforms to provide model clauses, maybe even tailored to certain industry users? For example, would it make sense to have as an example, a MED-ARB clause for an M&A agreement, or a typical dispute resolution and arbitration clause for a long-term distribution contract? Would that make sense, or would it be too granular and too complicated for the user to pick these clauses then?
That's a good question, and I'm not sure of my own opinion in this respect. When I was the Secretary General for the FAI, so I recall that I had a lengthy discussion with the Association for Franchising in Finland. And I think we didn't have a FAI model clause for that industry, but what they did after our discussion, so they actually inserted a clause, including mediation actually, in their recommendations for the industry, because they considered that a good way. So I think that's one way of doing it, that you don't necessarily need a model clause from an institution, but as a one field of business here, the franchising, you could do your own thing and maybe then discuss with the institution whether it functions or not. But I think there certainly is room for more model clauses in different fields. But I think it's important first that those clauses that we already have, that they are implemented and used. And of course, it's good to have new ones as well, but I think it needs to be balanced. If there are too many different clauses, it might be difficult for the users to understand what to use. Because as I just said, I think it's not the dispute resolution lawyers who pick and choose the model clause, but it's the users, normally the companies. And I think we need to make it simple and easy for the users, not too complicated.
Yeah. Maybe it's also about the model clauses going to the users instead of the users having to go to the model clause. If you think about lots of companies using AI now, using ChatGPT now, maybe would it be worth looking into, for example, having custom GPT or anything that you can speak to as a business owner, and that tells you, well, this is a good clause for you, and you should look into this. And here's the link to the FAI homepage if you want more information. Would that be something that should be explored, or is it too early for that?
I have actually not checked what would the ChatGPT say if I would ask about the FAI rules, for instance. I haven't tested it for this purpose. But interesting. Yeah, I haven't thought about that. But I think what I recommend for clients who are not lawyers and who are not in the law firms, but they are the companies using dispute resolution and making the contracts. So I think if they have a question about a particular contract, so they should always discuss with the lawyer about the dispute resolution clause, because there are so many things you need to think about. Of course, before I know that many companies don't have the resources to think about dispute resolution, and they are sometimes even forced to sign a contract where you just have something. But I always say to the companies that you have to remember that disputes and decision-making about disputes is also a strategic decision. And it has monetary effects, it has effects in terms of time, money, resources, human resources, other resources. So I think it's worth having the 15-minute call with your lawyer before signing the contract, because you cannot always use the same clause for every contract. Yeah. And that is something that the users don't normally necessarily understand, which is very understandable, because it's not, disputes are not their core business, and it should remain so. Yeah. So I think it's worth having the 0.25 minutes billing for checking the dispute resolution clause as well.
Very good. Heidi, thank you so much for all the information and all the input and all the insights you provided to us. From my end, it was a very enriching discussion. I learned a lot about FAI and about becoming an arbitrator in Finland, and becoming an arbitrator after having become a lawyer and working in other fields. Very interesting. Thank you for that.
Thank you very much. It was a pleasure for me to join.
Thank you very much. And with that, let me hand over to Anita and Leah for the rest of the intro session to the moot.
Yes, thank you to Sebastian. Thank you, Heidi. It was very interesting to hear both of your insights, and I sure hope that the Mooties here today feel the same way. If you have any questions, you now have the time to post them in the Zoom chat. Questions to Heidi regarding the FI rules, maybe regarding her own career. And yes, now would be the time to do so. I will give you a couple of minutes, or maybe a minute or so. On the screen, you will otherwise see the schedule for the upcoming moot court, for our upcoming pre-moot, and the contact details.
If there are any organizational inquiries, please contact us per email, as you have been doing for the last couple of months. Yeah, let's see if we have any Heidi-related questions. If not
at this time. I think we have we've touched upon a lot of topics.
Yes.
So I think
from my side for all the mooties, so I think it will be an interesting pre-moot, and then I hope to see many of you either in Vienna or Hong Kong. So I will be there as well. So it would be great to see you face to face.
Very much looking forward to meeting you in person in Vienna, Heidi, and meeting all of you mooties in person and in several of the moot rounds. Very much looking forward to that. And also from my end and from all of the partners and team members at Bodenheimer, good luck, have fun, enjoy the pre-moot experience, enjoy the Vis Moot experience. It will be, and probably already is, an unforgettable experience that will shape your career and your life to a certain extent. So all the best of luck. Thank you very much again to Heidi for agreeing to join us today for the intro session. And I'm handing it over to Anita and Leah for the final goodbye wave and the end of the session.
Thank you, Sebastian.
Thank you.
All right, it seems that everything was covered, which is always great. And we will, as Sebastian mentioned, we will see you in Vienna. If you have any organizational questions, please let us know. Otherwise, the first pleading will happen on Monday at 9 a.m. The login details for the pleadings will be sent out today and on Friday, so do not worry. Every one of you gets an individual invite.
Mm-hmm.
Should there be any more questions, just let us know. Otherwise, I hope you enjoy your weekend and the rest of the day, and bye-bye.
Thank you very much.
Thank you, everyone.
Bye-bye.
Bye.